I represent Robin Tyler and Diane Olson, who are seated in the front row here, and they are females, and they're among the successful plaintiffs in the marriage cases. By virtue of that decision, they were finally able to marry after years of deep commitment to one another, and having married, following the Supreme Court's decision, they are seeking to preserve their marriage under the law. I also represent petitioners Sherry Schroeder and Cody Rafferty, who are females and who are lesbians, and they're in a long-term committed relationship, and they seek to marry, but they're prevented from doing so by the passage of Prop 8. Prop 8 purports to amend the California Constitution by adding a new section, 7.5, to the Constitution to provide as follows: only marriage between a man and a woman is valid or recognized in California. Prop 8 imposes restrictions upon the right to marry, one of the most fundamental personal rights afforded to individuals under the California Constitution. These restrictions effectively rewrite the Equal Protection Clause of that Constitution, creating two classes of citizens for marriage purposes: those who can marry the person of their choice and those who cannot. In the marriage cases, the Supreme Court held that definitions of marriage which, quote, draw a distinction between opposite-sex couples and same-sex couples and exclude the latter from access to the designation of marriage are unconstitutional, end quote. In arriving at that holding, the Supreme Court expressly recognized that the constitutional right to marry is one of the basic, inalienable civil rights guaranteed to an individual by the California Constitution, that the right to marry must be understood to encompass the core set of basic substantive legal rights and attributes traditionally associated with marriages that are so integral to an individual's liberty and personal autonomy that they may not be eliminated or abrogated by the legislature or by the electorate through the statutory initiative process. That these core substantive rights include, most fundamentally, the opportunity of an individual to establish with the person with whom the individual has chosen to share his or her life an officially recognized and protected family possessing mutual rights and responsibilities, that the substantive right to establish an officially recognized family constitutes a vitally important attribute of the fundamental interest in liberty and personal autonomy that the California Constitution secures to all persons for the benefit of both the individual and society. The statutory definitions which restrict marriage to opposite-sex couples treat persons differently on the basis of sexual orientation, and that sexual orientation is a suspect classification under the Equal Protection Clause. That the distinction between the designation of the family relationship available to opposite-sex couples and the designation available to same-sex couples impinges upon the fundamental interest of same-sex couples in having their official family relationship accorded dignity and respect equal to that conferred upon the family relationship of opposite-sex couples. That the state interest in limiting the designation of marriage exclusively to opposite-sex couples cannot properly be considered a compelling state interest for equal protection purposes. By its terms, Proposition 8 contemplates, we believe, such a far-reaching change as to amount to a qualitative rewriting of the California Constitution and the negation of numerous decisions of the Supreme Court. In particular, Proposition 8 and new Section 7.5 of the Constitution would destroy equal protection for gays and lesbians who desire same-sex marriage, would insert distinctions based upon sexual orientation into our Constitution, would strip my clients and thousands like them of fundamental legal rights and attributes traditionally associated with marriage that are integral to personal liberty and personal autonomy. For those reasons and more, we filed a lawsuit on behalf of our clients against Prop 8 and challenged it as unconstitutional. Thank you.
Thank you, Gloria.
The first is kind of the policy side of things, the social and cultural thought process of, is the definition of marriage good or bad? Should it be changed? Should it not be changed? And that debate has already unfolded and culminated in the election on November 4th, where a majority of California voters answered that decision, at least for now, by saying that the traditional definition of marriage should remain the way that it has been since the beginning of statehood. The second debate really began the next morning when 3 lawsuits, well actually more than that, were filed to challenge Proposition 8. And the issue raised in this second debate, the legal issue, is who gets to decide what the meaning of marriage is going to be. And the common theme of these lawsuits, the claims that in them are that the people do not have the power. They do not get to decide what marriage means. That debate creates two sides. On the one side is rooted in the traditional notion of self-government that our entire country was based on. As stated in the Declaration of Independence by Thomas Jefferson, all government power derives from the consent of the governed. That is the people. In fact, the power to effectuate the will of the majority and the power to protect minorities all comes from the root of the sovereignty of the people. In the end, the people have the final say on what the Constitution contains and doesn't contain. The other side of this legal debate is essentially a brand new theory. This theory says that when it comes to issues involving personal or fundamental rights, that the court has a new job, new role, and that is to serve as a guardian of the Constitution, protecting the Constitution against amendments that aren't good based on their substance, based on their merits. The lawsuits that were filed, the plaintiffs more or less have taken the position that once a court has decided, made a decision and declared a particular right to be constitutionally protected, to be fundamental, that at that point the voters lose the right to change the Constitution and say the court was wrong. The Attorney General has rejected that argument but advanced an additional new argument and says, yes, the people can amend the Constitution with regard to individual rights, but only if the court thinks that there's a good reason for it, that it's justified. This whole concept, the underpinning of all these lawsuits, really introduces a constitutional revolution for our system of government. It essentially would throw the whole underpinnings of self-government out the window and surrender the people's authority over what the Constitution ultimately says to essentially a judicial oligarchy, where the court, drawing on something above the Constitution itself, we're not sure where it comes from. We might call it natural rights. Perhaps it's principles that come down from the heavens. Whatever it is, the court puts itself in a position above the Constitution, a position it's never put itself in before. And if the court adopts these principles and goes in this direction, it would really mark a historic and troubling direction for the court to go. And I think that at the end of the day, that truly is the debate. Who gets to decide? And as Constitution makers and amenders, are the people going to relinquish their authority over their Constitution?
Gloria? With all due respect, I think it's the Prop 8 proponents who are trying to change the role of the court to strip them of their power to protect minorities. As the United States Supreme Court explained in West Virginia State Board of Education versus Barnett in 1943, the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. That's a quote. Similarly, I would add that in California, our state constitution's declaration of rights to privacy, liberty, and equal protection cannot be set aside by a bare majority of the vote. It requires instead a constitutional revision, a two-thirds vote by the legislature, and then a majority ratification by the electorate, or a two-thirds vote of the legislature authorizing a constitutional convention, and then a ratification of the constitutional convention by a majority of the electorate. Prop 8 failed to follow the proper procedures and attempted instead to abrogate basic constitutional rights of a targeted and protected minority. We will do everything possible to restore and protect those rights so that we can all enjoy our fundamental and inalienable human rights and equal protection under the law. I am proud of my clients and everyone who has the courage to stand for equality. We shall overcome. Thank you.